Thank you for watching, liking, commenting, sharing, and subscribing right now.
Many of you know that my humble beginnings of being online, at least in a business capacity, started in Iowa, and I met a lot of people in Iowa who are also quite interested in the internet and how it was playing a role in our lives on an increasing basis, including lawyers. Yeah, so lawyers were, getting into the whole groove before some other professionals were, including Brett Trout. And Brett's a friend that I met when I was involved in some Iowa, I would say, political technology organizations, even though it wasn't really political. Any kind of organization just seems to bend political sooner or later. He's written another book, Cyber Law, A Legal Arsenal for Online Business. And I put a quote on the back of the book, but the only reason why is because the book is less than an inch thick, which means that I could digest it easily. If it was longer than that, well, or I wouldn't. And I don't think there are any pictures. Are there pictures in here, Brett? I don't see any.
No, there's two graphs. I had to keep it to a minimum, but it's really kind of a desk reference. Unless you're my mom, you're probably not going to read it cover to cover. But yeah, so it's pretty much just pick it up, find a topic, look at it, and put it back down.
Yeah, I was quite surprised. Flipping through here, obviously cyber law, I'd be thinking, well, this is just going to be total legal way over my head. But noticing sections on, well, it probably still is, but, seeing sections on blogging, on meta tags, on things that we tend, as geeks at least, tend to deal with on a regular basis and don't really think about, the legal entanglements, so to speak, as was said by a member in the chat room, but until it's a little too late. So this serves as a good desk reference, or at least a baseline reference for some of these things that we have in our life.
Right, no, it's great, and I'm a geek myself, and so I kind of wrote this for geeks that they tend not to go to lawyers until it's too late, and some of them are shy, some of them don't want to pay the $200, $300 an hour to talk to them, but this one, just to give you an idea of what the issues are, to keep you out of trouble, it's just a list of over the last 15 years, the questions I get over and over that I wish I could have talked and told somebody about 2 years before they came to me.
Wow, so this could actually lose you money if someone reads this and say, aha, okay.
Right. No, it actually is designed to lose me money, and when I talk, I'm going to go down to Blog World and talk, and I'm basically going to say, don't call me with these questions, because I give this advice I give over the phone for free, and so I'd like to give you advice that's worth it, that I can pay for, or that I can charge for, and just give you the free advice in a book. So. Yeah.
Well, I mean, and it is really, there's simple things. I suppose you're taking. How many questions did you answer? I mean, when I say it's a thin book, I don't mean that it's thin on information. I mean, you've got 19 different chapters and a handful of appendices.
Right. There's a lot of information. Basically, it's an inch deep and a mile wide. It's just issue spotting to give you an idea of, should I be looking into this? Do I need to go one step further? Or, yeah, it looks like I'm okay, move forward. I want to stress it's obviously not legal advice, but I think the number one thing to staying out of court and making your business move forward, especially in the IT area, is knowledge, and picking this up, reading the topic, putting it back down, I just think is something I wish I could have everybody do before they come talk to me.
Now, what about the legalities of blogging? Can you give me just an overview, like things to watch out for?
And yeah, we've written, I actually took a whole book on blogging that I wrote and just kind of condensed it down for this, but it's so important. It involves all the different issues. The biggest issues I get with bloggers are, hey, can I use this? And it's, typically this photo or that photo, and I'm like, well, unless you're absolutely sure, no, you can't. Even if it's on Flickr, whoever put it on Flickr might not be the owner, might not have taken it, and you can see that deal with Verizon. Even though they got authorization from the photographer, they didn't get authorization from the model. There wasn't a model release in there, and so the Creative Commons license didn't extend to allowing them to use the model. So using other people's work and what you think is fair use, which is probably not fair use, is the big problem.
Well, see, I've always, and maybe it depends on the source for content. When I record videos or just do random wacky things, some people may take a screen capture, or they may take a video recording of it and throw it on their own YouTube account or whatever. I don't get really bent out of shape about it. I've always taken the perspective of, well, I'd rather have them doing something than not doing something at all.
Right, and that's why you get a lot of WordPress, and that's why when you put Chris on Google, you're number one, because people like what you say and they want to share it. There's other people that are a lot more antagonistic, and if there was one thing I could take home from this book is it's not so much whether what you're doing is legal or illegal. The question is, how likely is the other person going to sue you, and how much money is at stake? And so even if somebody might be infringing your copyright, if you are a non-litigious kind of a person, it's probably less likely you're going to get sued if you're going after using somebody else's material.
All right, what about these splogs or spam blogs? I have had the biggest issue. It used to just be with Blogspot, Google's platform, which of course they purchased years ago from an outside company. And now it seems there's a plugin, and it seems just to be for WordPress, that will scrape RSS feeds and then post my posts, again, only quotes from the post. They'll link back to my original post, which I'm grateful for, but I can also tell that they're using the bulk of my content on their website because they've got ads on their website, and of course I'm not making anything from them.
And again, that's copyright infringement. Plagiarizing isn't that big of a deal. I mean, if you're an attorney or an academic, it's a problem. But if you're just an individual, taking someone else's ideas and putting them off as your own is not necessarily illegal or a violation of the copyright laws. But those blogs, when they're actually taking your quotes and putting them on there, they're putting attribution on there, which gets around the plagiarism issue. But that's not really an issue. They're taking your words and they're making money off it, and they're not giving you any of the resources. They don't have don't have a license to do that. That is copyright infringement. And assuming you could find out who they were and track them down, you would be able to get damages from them if you had a registration on your copyright.
Well, see, that's the thing. It's just not scalable. I mean, I literally will go through and have dozens of just random blog posts an hour get spammed by a different blog. It's just not. I can't keep up with it because we're now at the level of machine replication where they can scale. And of course, they're taking my content, repurposing it, generating revenue from it. And I've seen it. They're getting better at it. I mean, they're getting better at masking the fact that they're splogs. But still, I can tell. I mean, I just like a red flag goes up like immediately when I notice. Well, I can't tell who's writing this blog. It looks like a generic template. They're not really quoting in context. It just seems really generic. But I can't go after all of them. How can I, better protect myself if I can at all, knowing that they're going to scrape my content no matter, if I have full RSS feeds, content in my RSS feeds, or partial content in my RSS feeds. I've opted for the full content, with a couple of hacks, but it's still it's a big concern because the content that's out there, Google I think is pretty smart at detecting whether or not something is the original source or it's not, but I know that other people out there may not realize that they may be visiting a spam blog, not the original post, if they're not linking to the original post, or if they even bother to look at the original post that they're linking to.
Right, if there's 500 blogs out there and they're all owned by different people, and one of them's run by some 40-year-old guy in his mom's basement, playing video games, even if you could track him down and find him and sue him, I mean, he's probably going to be judgment-proof, so it's very difficult. Now, if there's a pattern and you can tell that, well, this is a bigger company and they are generating revenue, and you can send them a cease and desist letter and they continue to do it beyond that, then you can bring a copyright suit in federal court, and they allow for statutory damages, and the main thing is attorney fees, because every attorney needs a new jet ski. But I mean, that's the big thing that keeps them away is that if they have to pay the attorney fees, they don't want any part of it. And the other thing is that at some point, if you're really upset about it and you really want to make a point, you have to step out like the RIA did in Minnesota and spend a ton of money on one suit, getting a giant verdict that you might not ever collect on because the plaintiff might, or the defendant might go bankrupt. But by setting that precedent, everybody's saying, well, if I have a choice between stealing content from Chris or stealing content from Brett, I'm probably going to do it from Brett because Brett doesn't have this machine in place that he's just going to beat me silly when I do it.
Yeah, but you're also a lawyer. I mean, you've got your own blog. You're at bretttrout.com?
Right,
You're professional.
Yeah, and I tend to go after people very aggressively. So yeah, some of the things you look for, if it's a 6'4", 250-pound cage-fighting intellectual property attorney, probably not the guy you want to take content from. Chris Pirillo, probably not the guy guy you want to make mad. So once that's conveyed to them that they don't want to go after those types of people, then basically you can't get them to stop. The best you can do is show them where the other people live and tell them that you might want to look at that content rather than yours.
Now you mentioned Creative Commons, which I find a little surprising. We've got copyright law, trademark law, but to my knowledge, Creative Commons isn't a law, or there's no. Are there any? Does it stand legally?
Yes, it stands legally. It's just it's a contract, so it's under the law of contract on what can and can't be done, and the laws give you quite a bit of leeway in terms of what you can and cannot contract. That was be put together by Lawrence Lessig, who's a genius on these copyright issues, but even he, I think, was caught off guard on the Flickr deal, where the Creative Commons license under Flickr allows you to use the material, but it really doesn't take into this model release issue of right of publicity for the subjects in there. So Creative Commons is legally binding, and you can defend that and go after somebody who uses it in violation of that agreement. There's no specific law on that, but it's just the law of contracts.
Yeah, but here's the thing, it used to be, I'd imagine it used to be easier to go after people who are violating copyright, trademark, or anything. But now, if you don't protect your trademark once, you can lose the right to it. Well, how can you protect these things that are virtually unprotectable? Because there's only so much time in the day.
And you can pick your spots, too. If you give people the impression that it's okay to use your material in a certain way,
sure,
that's going to be held against you. Whoever this blogger is going to make an estoppel argument. But the judge understands you can't go after 5,000 people. Somebody with your kind of exposure, and the content is so valuable, everybody wants it, and you can't go after every gnat that gets in your eye. So you go after one, and you write them a cease and desist letter, make it very clear that that's a violation, and they're not to do that at all. Then the next time when you go after them, they're going to have a very difficult time using the estoppel argument to say, we thought it was okay to do this. So it's kind of a two-pronged approach, and the nice thing is the cease and desist letter is quite a bit more inexpensive than filing a federal lawsuit every time.
You know what would get you a lot of traffic and a lot of attention as a lawyer? If you built I'm sure you can figure things out, but if you had a script or a form that someone could step through that would build a cease and desist letter for a spammer or a blogger, and then basically fill in these fields, name, email address, physical address, yada, 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 press a button, copy and paste that into an email, I bet you people would just come and flock in droves and use that script and share that script all over the place.
Yeah, that would be good. I think the reason that it hasn't come up so far is because if there's ever a consideration where you're assisting someone in the unauthorized practice of law, you get in a little bit of problem. The other issue is that when it comes on a law firm letterhead, it has a lot more import than just coming from an individual. There's so many people big companies that send out cease and desist letters. You can find a template just about anywhere, because anytime some blogger gets one, the first thing they do is put it on the blog.
True.
But
in fact,
the final thing is that to send it out, you have to have reasonable investigation that there has been a violation before you send it out.
I had Jake Luddington and I got a cease and desist letter from Microsoft when we it wasn't in good fun. A cease and desist letter is never in good fun. But we were helping them. Well, we really were helping them seed the Windows Vista. I think the first beta. They had uploaded it, and they literally killed their internet connection. They couldn't serve enough. So he said, well, why not put it on BitTorrent? This network. That's kind of what its strength is. It says, but do it. You say, here's the torrent. Here's the hash, so that you can compare and make sure that this is the original binary that is untouched. And then I think we used, I can't remember what checksums that we used, just to verify that this is the original ISO or the original file for the beta. We put it, I think it's still up there, I think vistatorrent.com, I think, we still kept it up there. And we knew they were going to take it down, we just knew it. And they did, they ended up, I don't know if Jake has it or not, but they ended up giving us a plaque, the cease and desist letter and a plaque, It was at GnomeDex. It was just kind of, I mean, because they knew we were trying to help. I mean, they knew, I mean, we were both MVPs at the time. You know, we were just saying, let's, you know, try to help the community. They want to get their hands on it. You're letting anybody in the world use this. Here's the official, you know, we haven't changed anything. We're putting our reputations on the line. So they ended up, they did send us a cease and desist, but they did it in a very, I thought, the most friendly and humorous manner possible. And I unfortunately now, well, I wish Vista could have been better, but that's a different problem altogether. In fact, that's my leading into my next question. You know, I've had issues with Windows Vista, and we all kind of take our lives into our own hands when we use any new operating system. But Microsoft seems to, and whether this, I don't know if this is necessarily something that's that can be an issue, but with Windows Vista Ultimate, they promised, and this is more of a promise than probably a legal arrangement, but they promised that they would have released a series of bonuses or add-ons. And to date, the add-ons that they have released, well, they haven't really released that many, to tell you the truth, if you have or have not been following that. And I don't know if that's if we're going to see like a class action come out of that, which I don't think it's ever going to progress to that level. But is that something that's class actionable?
Well, it would be if they made an assertion. You know, if you relied on what they said and then you took action based upon that, and then that didn't come through, there would be a potential for a class action over a large number of people. Now, if they said we're going to come out with all these add-ons and they came out with 3, now is that a violation? And you know, if they didn't work very well, you know, I think they have a very strong argument to say, hey, we said that we'd come out with add-ons, we came out with 3. You know, the fact that they didn't work very well, that's a subjective opinion. So something like that, where you get into the subjectivity of it, you have a problem. Now, if they didn't come out with any add-ons and they said they were, and that generated, you know, a bump in the sales, then there's a problem. So I think it's a question of form over substance in that issue. I mean, I appreciate the fact that it doesn't sound like it came through, but whether that would be something that you could get a court to award you damages on would be a little difficult, especially if you purchased it before they made that assertion or made that promise.
What do you think about them, in a legal sense, backpedaling and allowing the extension of Windows XP to be sold with machines, or just you know, not ending Windows XP support because they've had so many issues with Vista, and they being people out in the general world, not necessarily just the business world?
In terms of the people doing XP because they don't like Vista? I mean, they don't think Vista's stable enough that they want to have it on things that they sell? Is that the concern?
Pretty much. I mean, you know,
yeah.
how does that, you know, legally, I mean, do you think OEMs, computer manufacturers, were telling Microsoft and saying, look, we have to put XP back on these machines?
No, it sounds like it to me. I mean, the computer people, the people who are selling the hardware, are interested in selling the hardware, and they really don't care. They want to make their clients happy, and if Vista is too difficult or too bloated or too expensive or too slow or too buggy, then they're going to go and try to promote and sell the best thing they have at the moment. And the fact that they're continuing to sell XP, you know, gives some indication that for whatever reason the consumer market is demanding that as opposed to demanding Vista.
All right, so I'm going to close this with a question about social networking. That's the big buzzword these days. You know, you can get an account anywhere, start sharing details about yourself, and I'm guessing skip through a terms of service in the process. You know, this just seems to be a whole, you know, just almost like a new type of law, social networking law. What do you think about this phenomenon, which I'm sure is not going away?
Yeah, no, absolutely. Every phenomenon has its own set of laws. You know, the multi-user role-playing games, blogs, and now social networking. And there's actually Chapter 3 covers social networking because it has its own ins and outs. The first thing is that you have to look at whether it's professional or personal. That makes a big difference in terms of what kind of damages and what kind of things you're saying. If you're a professional person and you're on MySpace and you're saying stupid things, I know a lot of people who have lost business, lost jobs because of things they said on MySpace. If you say something bad about somebody else, the rules of defamation come in there pretty tightly. You put copyright material in there. Almost every aspect of internet law impacts social networking website. And before you start doing anything that you're not sure of, you need to make sure that you have a little idea of what you can and can't do. Because, like you said, it's a whole new area of law.
Yeah, I lost it wasn't because of MySpace, but I ended up losing a paying gig because of something wacky that I did. I don't know if I necessarily regret it at this point, but just because I am who I am. That was a horrible Popeye impression, and don't sue me for it. So the book is available. Is it online through your blog?
It's actually on Amazon if you want to grab it from Amazon. But on behalf of your adoring fans, I think we're all appreciative of the fact that you didn't pull any punches, and you might have lost that one gig, but I'm sure you gained a lot more fans.
Yeah, I don't know if I'd call them fans, but sure. Sure.
Well, I'm one, so.
Sure. Yeah, no, it's something that I know. I like I said, I've been thumbing through it. Just kind of something. I'll thumb through it and like something will catch my eye. I'm like, yeah, I was just wondering about that. Someone was asking about domain name legality, and that's in here, and contracts, and it's a really, like I said, it's not a daunting experience. It's a very compact tome, so to speak. Yeah. So.
Would you like the cover?
What's that? Yeah, the cover's great. It's very comic bookish.
Yeah, I tried to put a graphic novel cover on it to give people, to get them to pick it up and take a look at it, because like you said, I've really tried to, I went from my first book, which was really a legal text, to this one, which is just ordinary people, to give them an idea what they need to be looking for.
Yeah, all right. Well, you'll see this video on YouTube, and I'm sure comments will ensue.
I think that's good, so thank you very much.
Yeah, for the most part. All right, thank you, Brett.